Welcome back to Canadian Justice, where we're discussing the defense of extreme intoxication and when the Supreme Court has said it's available. I want to talk briefly, Sina, about the Brown case and the context of the offense. In that case, it was a person who had consumed magic mushrooms, psilocybin, committed a violent act. Anything you can add to the context of the offense and how it relates to automatism as a defense?
Indeed, and certainly voluntary automatism, as we had indicated. I think in Brown, what's important is to note that he didn't have a history of violence, no mental ailments previously. He was consuming this drug in a safe environment with his friends. He did not foresee what could come about as a matter of ingesting them. And ultimately, the court did go through lengths of discussing these things. The circumstances in which substances are consumed and the results of them are very important.
It's certainly a terrible, terrible set of facts in all three of these cases. Now, Connor, since this law has been struck down, what might we expect Parliament to do in this case? Obviously, the law was originally acted in response to another case involving self-induced intoxication in Davio, as we talked about. So might Parliament revisit this law and change it and reenact it in a slightly different form?
Absolutely, Christine. There is absolutely a possibility that Parliament will rewrite this law. And in fact, the Minister of Justice, David Lametti, has already indicated that the government is considering its options, but is not committed to any particular option. In the Supreme Court of Canada's decision, it actually carved out a number of different alternatives that Parliament could pursue. So, for example, we could see a new offense of dangerous intoxication causing bodily harm. And that offense could be drafted in a way that is sufficiently nuanced to fix some of the constitutional infirmities that the Supreme Court of Canada identified in its decision. So to answer your question, yes, we could absolutely see a rewriting of this law, and the ball is now in Parliament's court.
Sina, anything you want to add there about the possibility of Parliament rewriting this law now that it's been struck down?
Indeed, I think Connor has hit the nail on the head. It's something that the Supreme Court discussed specifically in Brown, a number of options that Parliament could do, and this is something that will not go unaddressed.
Connor, just in our last few minutes, I want to talk briefly about the balancing here, because I do understand a policy rationale. We don't want someone to get away with a crime because they got themselves, drunk or high. We want people to be responsible for their actions, including the choice to become intoxicated to the point of automatism. So what's the balance here? Do you think the court got it right?
Well, Christine, that's a great question. The Supreme Court of Canada grappled with this question head on, and it recognized the important policy objectives that Parliament was pursuing. But at the same time, the court recognized that there are limits on what Parliament can do. And one of those limits is the constitutional rights of accused. And there's a way to give effect to Parliament's accountability objectives and its objectives of protecting individuals who are the victims of crime without violating an accused's charter rights. And that's what I'm hoping to see from Parliament. I think that's the right path forward, is to carve out a more nuanced law that strikes a better balance between the rights of the accused and the important policy objectives that Parliament is pursuing.
Sina, anything you want to add to that? Because as we've said, we understand the policy here. We want people to be held accountable for getting themselves into a dangerous state, but we also obviously want to preserve people's constitutional rights. Just 1 minute.
For sure. I think while we want people to be held accountable, but we only want that where it's appropriate. This is not at all to say that the person got themselves so intoxicated for the purpose of committing a crime and later arguing that they were in a state akin to automatism. Some people, like Mr. Brown, have little to no foresight of getting themselves into a dangerous state. And some people, like Mr. Sullivan, attempting to take his own life, didn't do that on purpose in terms of the ensuing act. They put themselves in a dangerous state of intoxication. And we shouldn't hold people who do not have the requisite guilty mind or are in a state where they're not capable of knowing something is morally wrong, accountable under the law.
Well, Sina Shabastari, Connor Bildfeld, I want to thank you both so much for coming on today and really giving this case the deep analysis it needs.
Thanks, Christine.